Hello, landlords. Today we're talking about the 8 mistakes that landlords make when they're trying to enter into rental property. Let's get started. So today we're going to cover 8 considerations that are important for landlords to make when they want to step into a rental property. Whatever the reason, you really need to consider these 8 things. Make sure you stay all the way to the end because each of these tips is helpful advice that you're going to learn from. The first mistake that landlords make is that they really just don't enter enough. Too many landlords only see the property at the beginning and at the end of a given tenancy. When a tenant occupies a space for 12 months, sometimes longer, if that's your practice, you're just not doing yourself a good enough service. You're putting way too much trust in your tenants, and it's in these situations where we see that landlords come across the worst situations with their property. They're finding damages that could have been repaired early on. They're finding causes of problems that could have been stopped and addressed before it resulted in damage. And so by entering often, you will get the best result and your property will be better off for it. My recommendation is entering at least twice within a given year. So if you've seen my videos before, you may have seen that I talk about a 3 and 9. So after 3 months and after 9 months in a 12-month lease, the landlord should be entering the property to inspect for the condition of the property. If after the first 3 months you already see major damages, that's a sign that you probably need to move on from this tenant. But if after 9 months you see that everything is going pretty well, this will give you a good insight as to whether or not you want to renew. And if you do renew, you should remember after the first 3 months of the next lease, so 6 months from the 9-month visit, you should visit again. And then 6 months after that, visit again. So within every 12 months, after the 3rd month and the 9th month of the lease, the landlord should be on the property. By doing this, you're going to be able, again, to stop problems before they escalate, and you're going to be able to assure yourself that this is a tenant that you are interested in keeping. Now, a good strategy when instituting the 3 and 9 inspection schedule is to have this conversation with your tenant at the beginning of the tenancy. If you're signing a lease and you inform them, by the way, after the first 3 months, I will be in to inspect the property just to make sure that everything's going well for you. By doing this, you're going to gauge 2 things. Number 1, you're going to see the condition of the property, and that's the most important thing. But number 2, you're going to get an instant reaction from your tenant. If that reaction is somewhat reserved or even hostile to the idea of you coming in, that should be an indication that this may not be a good fit for you. So you may not want to complete the lease signing unless they know that you intend to visit. In fact, what I would do is I would pull out the calendar and schedule the visit. Not ask them permission when you can come in, but let them know I will be coming in on month X on day Y, and let them know these things so that they're at least prepared when you follow through with that, but also so that they are conscious of the fact that you intend to return to the property during the tenancy. The next mistake that landlords make is failing to see what their lease actually says about entering the property. If you're not familiar with the provisions of the lease, whip out your lease and look at the provisions in it that talk about you entering the property. If your lease is completely silent on that, well, you might not have a very good lease, and if that's the case, I wouldn't recommend using it again. But generally speaking, your lease is going to have a section that describes this exact thing, your right to enter and when you can enter. By understanding those terms, you're going to be better off, and you're going to have a better relationship with your tenant. Now, some landlords are not even sure whether they are required to give notice and what those requirements are. Again, That goes back to not fully understanding what's in the written lease. Does your lease absolutely require a certain amount of notice? You may, for example, need to give 24 to 48 hours worth of notice because of the terms that are in your lease. Again, if you are uncertain, you must review the terms of your lease to make sure that you are in compliance with it. Landlords, if you like what you've seen so far, please click the like button. That's very helpful to us. If you have a question or a comment, please leave that below. I personally respond to many of these questions and comments every single day. If you have not joined our Facebook group, Texas Landlords, we welcome you there. Those of you who own property in the state of Texas. You can follow us on TikTok for more videos, as well as Instagram, and we welcome you to look for us there. Now, some leases don't actually require notice, or at least at certain times. Definitely on an emergency basis, you're not going to be required to enter the property to address an emergency. Your lease may say, for example, that you will first attempt, or you may first attempt, but can enter if. And so if your lease has that language, make sure you understand when it's appropriate and when it's inappropriate to show up even without some form of notice to your tenant. Next, particularly in the state of Texas, you are required, if you're going to enter into a rental unit, to come in during a reasonable time. Now, a reasonable time can be different depending on multiple factors, but it may not be 100% clear to you before you attempt to enter whether or not it is reasonable to enter at this particular time. Maybe you have a tenant who works nights and it would be unreasonable for you to show up at 8 in the morning just as they are going to sleep. And so understand that the idea of a reasonable time to enter is based on the work schedule of your tenants, possibly whether or not minor children will be in the property alone without supervision, and various other things that could make your time frame unreasonable for the set of facts for your rental. Make sure that when you are entering, that the time itself is reasonable. Next, in the state of Texas, you have to consider whether you are entering in a peaceful manner. This is one that we get a lot, where a landlord will enter and all of a sudden the tenant becomes hostile and they threaten to call the police. Sometimes they do call the police, and the landlord is shocked when the police asks them to leave or to come back at a certain different time. The law is set up in this way actually for your protection, landlords. If a tenant is hostile, there's no reason for you to be there because things sometimes escalate into violence. Not often, but this is the kind of thing that could result in that. I've heard of landlords who tell me that their tenants talk about the Second Amendment and their right to defend their property. And while these things are true from legitimate threats, you have to take this into consideration. Has the peace been broken? Because even if the peace is broken by the tenant, you simply cannot enter. Now, too many landlords simply allow their tenants over and over to deny them access to the property. Many times it's because the landlord simply doesn't understand their rights under the lease. They don't understand what the state law has to say about their right to enter. And so I'd like to share a few things about what you should do if your tenant has denied you access in violation of the residential lease. The first thing you should do is you should issue a notice of default. Make sure that you issue a notice in writing to your tenant, letting them know that what they have done is a violation of the lease. You can even cite the provision in the lease that allows you to enter in the way that you have attempted. Again, if you have shown up at a reasonable time and have attempted to enter in a peaceful manner, but they prevented you from entering either by breaking the peace or by simply barring the door and not letting you in, they have committed a default under the terms of your lease that allows you to enter. By sending a written notice of default, you're informing your tenant that repeated instances of this denial might result in an eviction. Let's say that the time has come that you are evicting, and perhaps it's not because of denial of access, perhaps it's from failure to pay rent or some other matter, but the question that we get a lot is, am I allowed to enter during the eviction process? And so this is it can be kind of a touchy situation. Yes, you are allowed to enter, but the real question is, should you enter when there's not a legitimate need for it? If you're doing a routine inspection, you might want to enter if you fear that the tenant is doing some damage to the property, but be cognizant of the fact that the chances for hostility rise during the eviction process. Additionally, if the tenant has asked for a repair, you're probably going to want to address that repair, particularly if it is one that affects the health and safety of an ordinary tenant, because you don't want them to use that as a defense or a basis against paying rent, which shouldn't be valid, but sometimes is used in the eviction court. And so if the tenant requests a repair, naturally you want to enter. However, if you attempt to enter and they, again, bar the door or are hostile to your entry, issue another notice of default, so that at the very least, if the issue comes up, you can address that issue in the court. The whole process of eviction, it can be quite complicated, but in terms of entry, if you have a valid reason to enter, some emergency need, for example, yes, enter or attempt to enter, but be aware of the fact that the tenant will likely be hostile. A landlord's right to enter is one of the most fundamental rights of property ownership. You're going to want to exercise that right, again, in accordance with your lease and in accordance with state law. And this is going to be the way that, number one, you make sure that the rental property remains in good condition for your tenant while the tenant remains in possession. But number two, that small problems don't escalate into something much more substantial simply because you had no idea that they existed. I hope that you enjoyed today's video. YouTube seems to think that this particular video will also be helpful for you. And watch all the videos on this channel. We enjoy that very much. And until next time, landlords, happy leasing.